Thank you, Matia, and thank you all again for joining today's webinar brought to you by the Tribal Law and Policy Institute. For those who just joined us, today's webinar is titled Strengthening Tribal Victim Protections, a Guide to Drafting Victims' Rights Codes, and will be presented by Heather Torres, Program Director at the Tribal Law and Policy Institute, and Bonnie Claremont, Victim Advocacy Specialist at the Tribal Law and Policy Institute. And I will now turn it over to Heather and Bonnie to introduce themselves and to get us started.
Good morning. My English name is Bonnie Claremont, and my Ho-Chunk name is Rajarenga, which means called upon woman. And I am a citizen of the Ho-Chunk Nation. I've been with the Tribal Law and Policy Institute as the Victim Advocacy Program Specialist for about 21 years. And prior to coming to TLPI, I was a victim advocate for many years. I would say maybe 25 years as a rape crisis advocate, a domestic violence advocate, and had the opportunity to work with many victims around issues related to violence against Native women in particular. Thank you for joining us. Turn it over to Heather.
Thank you, Bonnie, and hi, everyone. Thank you so much for joining us. My name is Heather Torres. I am a citizen of San Alfonso Pueblo and a descendant of the Navajo Nation and Mexican peoples. I'm zooming to you from Southern California. I was born and raised in the Inland Empire, and I still have my home here. And I am the program director at the Tribal Law and Policy Institute. And I get to work with Bonnie, and I like to say our victim advocacy unit of staff who work on these issues and supporting and tribes in creating systems and responses that are intentional, tribally specific, and focus on victim needs and incorporating culture and tradition where possible to assist the empowerment of victims. I'm trained as a lawyer, and one of my roles with TLPI is the creation of our legal code resources. So today we're pulling information that is housed and contained in a tribal legal code resource that we created focusing on victim rights and victim rights code development. So we're happy to share this resource with you today. And we thank you for joining. And please feel free to send us messages in the chat along the way.
Okay. So, all right, I'll get us started. Looking at the learning objectives, and these are just a few. Hopefully you'll learn more than what's listed here. You'll gain an insight into core victim rights, and we'll be discussing the importance of protecting victim safety through victim rights codes development. And we also will be discussing best practices for aligning tribal codes with community needs and cultural values. And also we'll walk through steps to drafting tribal victim rights codes and implementing victim-centered legal provisions within tribal justice systems. And I wanted to just add a little bit because I did a lot of advocacy work way back in the early 80s. And this was at a time when the whole victim rights movement and new legislation was being introduced for at the federal and then ultimately at the state level to have victim rights. Prior to this, there wasn't anything, there weren't any laws, statutes to protect the rights of victims. So in all the work that I did through the years, or those early years, victims would often say that, how come even the terminology of criminal justice system, right? There's justice for criminals. What about us victims? That was such a common reaction. And when you look at, the rights of perpetrators, they have the right to a speedy trial. They have a right to testify or not. They have the right to have representation, right? So there was nothing at that time until, legislation happened, and then it took time to actually get them on the books and start um, adhering to those laws. So those were I wanted to add that little bit of history for the victims that I worked with way back in the early 80s. Next slide. So I've been doing this work for, like I said, for a long time, kind of I'm like archaic, but I remember a lot of the work that was done in those early days. And initially, there was a task force that said, victims need rights, and many of us were working with victims, and because those rights didn't exist, that was really a big barrier for them to access justice within the criminal justice system. So there was a task force on victims of crime, and they were the ones that made the recommendations to improve that. And then the creation of programs designed to assist victims of crime, such as the victim compensation funds, and then also additional support services for victims. There, along with that, there was an increased awareness and sensitivity to the needs of victims. In crime victims. And then there was greater inclusion of victims in the criminal justice process, where there was more of a voice of the victims in what they were experiencing, how the crime impacted them, and what they wanted from the system in order to feel safe, to have access to information and so forth. So the passage of laws at the local, state, and federal levels that establish those victim specific rights for victims then came to reality after that. It's like a slow process, though, with the whole, where bills are introduced and then they're enacted and so forth. So it took time to actually see those, be able to practice those at working with victims. Next slide. So I always say that, the scales of justice kind of tipped a little in favor of victims of crime, which was really helpful to have those on the books, so to speak, because we knew they were there, but they were often overlooked. They were often the resources. Sometimes there's laws without having the appropriate resources attached to the laws, right? So that was a huge um, problem. And especially when we talk about, you have to bear in mind, and you all know this, I'm preaching to the choir, that without resources, these laws are great to see them on the books, right? They're, it feels better to know that victims have rights and to have that recognized. But then without the resources, and even more so for victims that are in tribal communities, trying to access some of those resources then was a huge obstacle, because often those resources were more in urban based or in areas that were hard for victims to access. Next slide. So, right from the beginning, when an assault happens, the impact on victims, because everyone is so different, how that crime impacts a victim varies. And especially, it could be even more traumatic if the victim is known, the perpetrator is known to the victim. And, so we're looking at the additional emotional trauma. Sometimes that includes like betrayal. How could someone that said they love me harm me in this way? So not only the physical injury, but also just the emotional trauma.
But hopefully Miss Bonnie can rejoin us as she has that victim advocate perspective and knowledge of this area. But with this slide here, we really wanted to talk, to share with you all about how victim impacts. It's not just a crime that happened and occurred, and that's what a victim is going to be healing from. And if a victim does choose to report their crime and pursue legal action, there are opportunities for the victim to be unfortunately re-traumatized during that process, including during investigation, after the suspect has been arrested, and even after defendants are released from prison. So when we talk about victim rights codification, and we'll talk about this a little later in the presentation, is we'll talk about all the different disciplines that are involved in actually enforcing and implementing those victim rights once they are codified. And everyone plays a role, including the victim advocate, of course, who's helping the victim navigate the legal process, but also all of those disciplines and professionals that the victim will interact with during that process. And I see Bonnie, yay!
Oh my gosh. I'm nervous. I'm sorry, everyone. My mouse and my touchpad on the laptop for some reason is not working right. So I apologize. Thank you, Heather. I don't know what all was covered, and
I mostly fleshed out that third bullet about how during the criminal justice process, victims can often, unfortunately, be re-traumatized if the other disciplines are not victim-centered, or if victim rights that are codified are actually not being enforced or implemented.
exactly. And oftentimes what was happening is the victim wasn't being informed, like when actually the perpetrator was jailed and then released. That becomes a really volatile situation, especially if there's threats against the victim for reporting. And so it's so important. The safety issues, I can't stress enough that the victim rights were to provide protections for victims, especially those that are entering the criminal justice system. And the information that they receive is so critical. For example, like I said, when they're released from jail, they need to be informed, and sometimes that information fell through the cracks, right? In the history of stalking, especially on the part of the perpetrator, if there's that crime happening, oftentimes the crime of stalking gets kind of minimized or trivialized. Well, he just maybe happened to be in the same place at the same time. But there's a really high lethality potential in the stalking crimes, because oftentimes that's like a measure of power and control, where the perpetrator is just wanting to send the message to the victim that they're watching, they're keeping an eye on what they're doing, where they are, and so forth. So that often those crimes end up in homicide of the victim. Next slide. Oh no, here we go again. I can't see the
It's okay, Bonnie. We're on victim fears and why victims may the different fears that victims might experience.
Okay, sorry. Gosh. I can't see the slide, but there's, for right from the beginning, even before reporting, there's a lot of fears that, sometimes the victim rights laws can kind of ameliorate those and address those kind of fears. So the victim has a little more trust in what's going to happen. There's fears for their personal safety, for their lives, the lives of their children, fear of being killed by the perpetrator, especially if there's threats that were made. Oftentimes, victims are afraid of losing their children, especially if there's a case involving child protection. If they have a case in the system, they may be concerned about that. If there's warrants against the victim, and oftentimes, the warrants could be for misdemeanors. There could be warrants for traffic violations that the victim is concerned about being arrested for. So they don't want to make themselves a little bit more vulnerable to being arrested, especially if they have children, right? They're concerned about their privacy and confidentiality violations. They're afraid of losing their job. They may be, single parent, and or there may be concerns about losing their housing, and and then also just adverse treatment by the criminal justice personnel. And that was the case in a lot of situations where they were not taken seriously. They weren't their crimes were often sort of minimized, and they were often blamed for the crime that happened to them. So a lot of mistreatment. And I can't stress enough the fear about losing that confidentiality, where everyone knows everyone in tribal communities, right? People have scanners and there's social media. And so for a lot of victims at that time, way back before victim rights laws happened, they're just the fear of gossip, the fear of someone knowing, in the courts that I've reported, or someone knowing in the police department, the law enforcement, that I've reported this. And it was difficult because oftentimes they would maybe make a report and things would just not go well, and they would say, forget it, I don't want to move forward with this, right? And that was frustrating because law enforcement and even the prosecutor's office, if they felt like they had a strong case, would say, you have to talk this victim into not backing off, that this is we can do this, we can get this, but we need the victim. So I always tell the people in the system, well, without a victim we have no case. So it's in everyone's best interest to keep the victim at the center and to keep them involved. Next slide. Oh my God. So there's different types of advocates, and I just wanted to make sure that you all are aware, and you probably are. There's what we call grassroots advocates, and many of them can be tribally based, or they could be based in nonprofit organizations, in victim advocacy programs, shelters, rape crisis programs, sexual assault programs. And those are, like I said, a lot of them are nonprofit or tribally based. We also have advocates in the Bureau of Indian Affairs. They're called victim witness specialists. So they work with victims that our clients are victims of the BIA. We also have the federal victim specialists. They work out of the AUSA's office for cases that are being charged. And basically they work with victims to help prepare for cases, prepare the victim to testify. And again, victims have to testify, right? So when we look at victim rights, that's still a problem with a lot of victims, where they say, well, the perpetrator has a right to decide whether or not they want to testify, but victims have to testify. That whole thing about you have to be faced by your accuser. So that's the job of a lot of the victim specialists in the AUSA's office. So it's important for advocates to work with one another, communicate with each other, because they have different roles. The main barrier, I believe, for those that are based in those systems offices like the BIA or at the federal victim specialists, they are accountable to their colleagues within those offices, right? So they share any information that the victim shares with them. So, as grassroots advocates, we're bound by the confidentiality laws, and that's a right to victims. That's an important right, to ensure their confidentiality and make sure the victim knows they have that right. So, but with those that are systems based, they share information with their colleagues because they're preparing cases for prosecution, right? So it's a huge distinction, and we always take the time to make sure victims know that difference. Okay, next slide. So how are victim rights beneficial? It forces the justice system to provide some protections for the victim to foster safety. Again, safety is so incredibly important. whatever door the victim enters in the criminal justice system, it's so, and I'll repeat this probably in later slides, it's so important for that victim to know their rights. And for those responders, for those people within whatever door the victim enters, to know that, to make sure the victim is aware of their rights in whatever way that works for a victim. And also it ensures some measure of prevention and support cooperation with prosecutions. So to ensure that throughout that process that the victim is aware of their rights, and we'll talk more about the rights specifically, but there's a lot of benefits that can help the victims. So it codifies victim rights. It gives your tribe that opportunity to codify victim rights, and to be able to communicate that as part of the process with victims, which can enhance victim reporting and victim participation in the prosecutions. Because oftentimes, like I said, they don't want a part of it. They don't want to be involved in that. They're especially when the victim is re-victimized and re-traumatized within the system that's there to help them, to support them, to provide that safety. Next slide. Oh, this mouse. Oh my God, April.
No worries, Bonnie. I think we're on our what's considered the core victim rights. And so as Bonnie mentioned, there was a movement to produce these rights that we now see as core or foundational. You'll see these in federal victim rights statutes. You'll see them commonly in state victim rights statutes. And so we thought we'd talk through these core rights so you're aware of them. Many of you probably already are. First off, right to, actually looks like okay, yeah. So we've got the right to be treated with fairness, dignity, sensitivity, and respect, the right to attend and be present at criminal justice proceedings, the right to be heard. As Bonnie mentioned, this can be the right to confer with the prosecutor, submit a victim impact statement at sentencing or parole, and other similar proceedings. We have the right to be informed, and Bonnie stressed the importance of that right throughout the process, including release of the offender, informing the victim of those legal rights that have been codified. And we have including the available benefits and resources, making sure that the victim is aware at each step or each phase or each door, as Bonnie mentioned, that what they have available to them, and to make sure that they feel empowered throughout the process. We have the right to protection from intimidation or harassment. This is particularly important because sometimes others besides the offender may be looking to intimidate or harass the victim, or to prevent them from seeing a prosecution through. And examples of how that could be, the right to protection could be implemented by a justice system, could be a separate waiting area to ensure that there's separation between the victim and the accused, no contact orders, prohibiting improper questioning from lawyers. So there are lots of ways that the right to protection is essential to victim safety throughout. And we also have the right to restitution from the offender, so court-ordered reimbursement from offenders who have caused financial harm. And I think I saw a chat around the statutes that we're referencing, and we actually have a slide later in the presentation that includes those for you. But we have the Crime Victim Rights Act and the Victims' Rights and Restitution Act. The Crime Victims' Rights Act can be found at 18 U.S.C. 3771. And the Victims' Rights and Restitution Act can be found at 34 U.S.C. 2141, which outlines the services to victims. So those are two citations for you to those federal laws. We'll also have links for you to explore by state. The National Crime Victim Law Institute has a really great database, as well as victimlaw.org, which is a searchable database provided by the OVC TTA Assistance Center. Next slide. So additional core victim rights include the right to privacy, protecting personally identified information in the criminal justice documents that you're filling out. There's lots of forms and things that are filled out and need to be protected to ensure that the victim's address, name, those types, that type of contact information is safe. Compensation records, court testimony, all of those things the victim has a right to privacy to. We have the victim's right to apply for victim compensation. So the right to be financially compensated for certain injuries or damage caused by the crime. There are usually government programs, and the states operate those victim compensation programs that the victim can apply for. We have the right to expeditious return of personal property that's seized, as that is often a method of control that's exhibited by perpetrators. The right to a speedy trial and other proceedings free from unreasonable delay, and the right to enforcement of these rights. And we can't stress enforcement enough. Like Bonnie said, it's good to have them on the books, but if they aren't being enforced and implemented, then the purpose and intent behind those codes is lost. And the right to enforcement often falls on different disciplines within different professionals within a criminal justice response. So it's important to, once those codes have been codified and exist, that everyone receives training and awareness to ensure that they are doing their part in making sure that the victim's rights are properly administered. Next slide. Here we just wanted to add a little bit more commentary around restitution. And I know Bonnie has some particular thoughts that we wanted to share around what tribes can do around restitution. But here we wanted to make sure that we highlighted that the federal system allows mandatory restitution in sexual abuse cases. So this is what is outlined here. It's found at, and the sexual abuse cases can be found at 18 USC 109A. And the mandatory restitution language that we have here on the slide can be found at 18 USC 2248. And again, it says the court shall order full amount of victim losses, including costs for medical services, physical and occupational therapy and rehab, transportation, temporary housing and childcare, lost income, attorney's fees, plus any costs incurred during the obtaining of a protection order, and any other losses suffered by the victim as approximate result of the offense. So again, this is in the federal system, and it's mandatory restitution in sexual abuse cases. So we wanted to make sure that we elevated that for you all. And you know, if a tribe could also consider ordering mandatory restitution if the tribal codes support that request. And so there are really some opportunities for the tribe to connect to their cultural resources and their tribal resources for victims. And here I wanted to turn it over to Bonnie to talk a little bit more about that.
Yes. Well, as an advocate coming to TLPI, never ever did I thought that I would be involved in helping tribes develop codes and laws, because in my mind, I always like kind of believed that that was just up to lawyers, right? So having worked with a colleague of mine, her name is Sarah Deer, and you know, she believes strongly that it wasn't just lawyers that, you know, should be involved in code development for tribes. And especially that, you know, tribes can, because tribes are sovereign, can, you know, develop any kind of laws that are appropriate for them. And so when we apply this, this kind of thinking, you know, which is for me at the first time I went out, I was like, wow, I'm here on site with this tribe, helping them with their domestic violence code. And actually, you know, the language that they utilize, it can be their own language, right? So, you know, that was something that was an eye opener for me. Like, it doesn't all have to be in English, that if there's some language that's important to them that sometimes are in our languages, in our tribal languages, they're difficult to even put into English, right? Because they hold so much meaning and so much more power than how it's translated in English, right? So I always, encourage tribes to look at that when we look at victim rights, even when we talk about things like restitution and the kind of costs that are involved when a crime occurs. And back then, there was victims who couldn't, even transportation, have their Indian cars, and, it was hard for them to get to being able to appear at hearings and so forth. And there we were as advocates trying to transport people back and forth from the res to where they had to work with the prosecutor's offices, whoever those were. There's also costs involved in, if they're doors were knocked down, or if there's other sort of damage that was done to their property, for example, or if they, want to have a healing ceremony, for example, there's costs involved in that, where they want to give gifts maybe to the traditional healer that's going to do the ceremony, or if they want to provide some food, for example. So these are all, for me, that the kinds of things that can be ordered or can be available through restitution. So even the use of, legal terms or terms that, can be incorporated in the tribal code, there's examples of that we can provide, that I've seen in my travels, where tribes utilize their own languages within their tribal codes. And especially incorporating the values in their codes. Why is it important to keep people safe? Why is it important to keep children safe, for example? So, and how, restoring those traditional values and incorporating them to, even provide a little bit more strength to victim rights codes. Next
Bonnie,
slide.
sorry,
Uh-huh.
before we move on, we did have a question about any kind of information about what could be put in place or is in place for children that are witnesses or are part of a domestic violence assault case. And I'm assuming that is in regard to children's rights.
When cases are being put together, they should be given a voice. And especially when we come to, the victim impact statements, definitely when we're talking about sentencing, that should be taken into consideration, I would say, at that point as well. If there's been additional harm that's been done to the children, certainly they have, there should be some services available to them that could be covered. And it's really up to the tribe what they want to do. It doesn't have to replicate federal laws. Tribes can do whatever they want. If they believe that children are harmed by witnessing the violence, then absolutely yes, there should be some provisions made within their laws to provide them some, either whether it's counseling, therapy, healing ceremony, whatever that might be. And especially safety. What kinds of safety measures are being taken in to be able to utilize the laws to, ensure safety, whether the kids are, in their homes or at school or wherever, whatever, the alleged perpetrator may have contact with them, especially in domestic violence cases, because there is cases that are known where perpetrators kidnap their children. So especially having, supervised visits and so forth, those are all part of the work that is being done with victims and how their children are impacted. I don't know if that answers the question, but.
Thank you. I think it did. And also, Heather did drop in the chat a link to a resource around children and youth in tribal communities, just to note.
Thank you. Next slide. So Often you'll hear the term victim-centered, and basically what we're talking about all up to now is really taking a look at the kind of response that the victim receives in the criminal justice system. And like I said before, and I'll probably repeat this again, whatever doorway that victim enters in the system, it's so important to think about, what does that mean to that particular agency, that particular department, when we talk about victim-centered. So to also keep that within the co-development process. So the approach is defined as a systematic focus on the needs and concerns of a victim to ensure the compassionate and sensitive delivery of services in a non-judgmental manner. This is so important. You would think it's a given, right? But it wasn't always that way. A victim-centered approach seeks to minimize re-traumatization associated with a criminal justice process by providing the support of victim advocates and service providers, empowering survivors as engaged participants in the process, and providing survivors an opportunity to play a role in seeing their perpetrators are brought to justice. This is, I just can't stress enough. And this happens in a variety of ways where they're informed of their rights as victims right at the very beginning of contact with each of those systems as they enter the system, right? So informing them of those rights in whatever way that's appropriate, and also keeping them informed, which is one of their rights, keeping it informed at every step of the way. And also, when decisions are being made, to keep them informed of those decisions. They may not have the power to change those decisions, especially when we talk about charging the perpetrator, but at least it's important to keep them informed because there may be some additional information that a victim has that may impact that decision, whatever it might be. So whatever victim-centered means, because again, I always encourage people that work in the criminal justice system is that, without the victim, there is no case. There is no case that can be built. And the more involvement the victim has, I believe, the stronger the case for prosecution. Okay, next slide. Um, you know, is this, what slide are we at? Oh my God.
Feel free, Bonnie. It's our TLPI philosophy slide.
Okay. We say the laws should come from the community. And that, like I said before, it's important that they're not just replicated in what exists in the federal laws or in the state laws. And also to involve the community as appropriate. Bring in those traditional healers, for example, advocates, whatever is appropriate. I always say a team approach is a really good approach when we look at co-development. Attorneys don't necessarily have all the answers. They can be beneficial and essential to the code drafting process to ensure the code is effectuating the community's vision. And that's a good term, that vision. And I always say, to have those statements early on in the codes, in the laws. Why does this code exist? What's the tribe's vision of why this code is important, right? If it's about protecting the citizens, then that should be stated early on that, the tribe values the safety of their citizens at every juncture, whether it's in their homes, whether it's in their places of employment, in the schools, and so forth. And also providing tools and examples. That's what we do at TLPI. So we provide examples of, other tribal codes, which can help, right? Because from there you can get ideas, and it facilitates discussion for each tribal community engaging in co-development work. And so it's kind of like sharing of information. It doesn't necessarily mean that you take it and just apply your own tribe's name, but it also spurs some discussion and ideas. So those can be found at the link there provided at the bottom. Some examples and resources of tribal codes. Next slide. I'll turn it over to Heather, I believe.
Oh, thanks, Bonnie. Yeah, so we like to say that culture is the cornerstone. So just, elaborating on what Bonnie shared as TLPI's philosophy to tribal code development, we really encourage tribes to think about their cultural and traditional understandings of how these situations were handled, and are there opportunities to use your tribal code, your tribal law, to exemplify your values and your understandings of responsibility and accountability. And so we really encourage looking and not just doing a copy and paste, right? Or not just adopting another tribal code because it's another tribal code, right? So we really, again, encourage and really foster through our materials to assist tribes is, you'll see when you look in some of those resources, we include discussion questions and exercises and worksheets, just so folks can really think about how, tribes are sovereign. How can we ensure that our laws are really reflective of our community norms, our community's values? And so it's really a cornerstone to our work. And so we try and make sure that we are sharing that with everyone that we work with when they're working on code development. Next slide. We just wanted to share this image with you all as well and offer to you that laws are like a vessel to enforcement, to maintaining community safety. So just as, pottery has a purpose, regalia has a purpose, baskets have a purpose, laws and codes have a purpose as well. And certain code provisions can function similarly to symbols or designs that we include in something like pottery or basketry. And really can inform how an overall code should be guided and interpreted, how we're defining particular words, the use of tribal language in tribal codes. All of that can really be guided by leaning on tribal cultural understandings and values. If someone can please provide, I see the chat, someone asked for some of the code resources. If someone can put that in the chat for our attendees, that'd be great. Next slide, and I think Bonnie touched on these next ones a bit here already. Who should develop tribal code? Tribal leaders, community members, advocates, and even survivors of crime. If they are in a certain place on their healing journey and they're willing and able to participate, they are a crucial voice to particularly developing victim rights codes. And so we encourage folks to think broadly about who should be part of the team. But no worries if you're kind of charged with the task of developing tribal law, an ordinance, or tribal code. There are resources out there to support you, including those from TLPI. And don't be afraid to reach out to others to talk through what types of changes you're tasked with. So we again encourage that thought process around developing a team. But if you happen to be on your own with a task, feel free to reach out to us and to other TTA providers. Feel free to reach out to your colleagues at other tribes to see how they have handled this issue. The availability of tribal codes, access to tribal codes and samples has greatly improved, including some of the resources that we highlighted today, like victimlaw.org and the National Crime Victim Law Institute law library as well. So again, we highly encourage the engagement of community members. It's not just, as an attorney, it's not all about attorneys when developing tribal code. Next slide. So these were just some general tips that we wanted to offer. And so we wanted to talk with you all about considering drafting a vision statement. And I know it might be, kind of different to think about if, I'm drafting tribal code, why do I need a vision statement? And so, but there does need to be that intention. What are you trying to achieve with the code, right? And so I think Bonnie was going to offer some more commentary here about the importance of visioning and looking through what you currently have on the books.
Yes, I think it's really important to do kind of your own homework and what's important to you to incorporate into your codes for victim rights and victim safety. And again, like I mentioned before, I think it's really important to have a vision statement at the very beginning, and that tends to guide a team's efforts around what's important to incorporate. And sometimes it's looking at, like I said, other tribes, to review your own codes, to look at what are the gaps, what are the conflicts, and even some of the borrowed language that you have in there. But I can't stress enough the importance of including your own values and your beliefs around certain issues related to the crimes that are happening, and how to keep victims safe and ensure the participation of victims and those involved in the crime in cases, and especially as the case moves forward, that victims have those rights enforced by everyone within that system. And also just reviewing federal law that may be applicable, so that um, that if there's some necessary provisions, that your law contains certain kind of language in order to access certain kind of benefits for victims. I think that's also really important to include in a code. And bringing in tribal elders in this process, when we look at that team approach, again, I say is really important to get their input as far as incorporating customs and beliefs and traditions around these issues. Next slide. Enforcement. Oh my gosh, enforcement. So incredibly important. And when we talk about enforcement, it's looking at how each discipline in these circles can enforce, the victim rights, the laws that you develop. And it's really the responsibility of each of these disciplines to enforce those rights. And and also all keeping in mind the importance of safety. When we would inform victim of their rights, sometimes maybe we would put them in a brochure, right? Somewhere on a panel of that brochure, to say, here, look at, this is your victim rights that you have, and then review them with each victim. And sending that written document is really sort of, you have to consider the safety measures, because there are perpetrators that are, maybe she's still with her perpetrator, right? Or maybe they will come back around, or somehow or another they would see that victim has reported their assault to law enforcement, for example, and law enforcement is informing them of their rights and sending them with this brochure. It's important to think about that, and to say, is it safe for you to take this with you? What we would have is a big poster in the place where we would visit with victims, where we would look at the report that was made to law enforcement, and as advocates to look at the what's involved in that report and what the next steps might be. But at the same time, in that very room where we would meet with that victim, we would have a big old poster that would list their rights, and we would review those rights individually with that victim and ask if they understood that. And also to say, if as an advocate, I will keep you informed if it feels like your right is being violated. Then we need to work on that. We need to backtrack and see what happened. So the enforcement is really up to each individual agency listed in these circles, because without that enforcement, the law is weak, right? It isn't doing what it's supposed to do. So again, keeping that victim at the center and informing them of their rights at every juncture in the process. Heather, do you have any more to comment on enforcement?
Yeah, I just wanted to add that in the resource, the condensed guide for drafting tribal victims' rights codes, one thing that we thought about was, assisting folks in enforcement. Maybe they just are stuck on how they go about implementing or providing the rights to the victim. And so in part 4 of the guide, you'll find charts by discipline, by these circles that we have here on the screen that outline possible enforcement steps. So if you're in the position of talking with individuals about, or your criminal justice system is looking at its response and how it's providing victim rights, it might be good charts to just, there are one sheets in there, one or two usually sheets in there that you can just print out and talk about, or maybe educate folks as well within the justice system about how they might go about actually implementing the right. So we know that sometimes folks struggle with actually implementing and holding their responsibilities to high regard. And so we thought we would offer that within that resource. And like Bonnie said, if it's great to have it on the books, but if it's not actually being implemented, then there aren't really any rights that are being offered to the victim at the end of the day.
Next slide. So this is just an outline of the roles of each discipline. As like I said, the door that the victim enters. We have the victim advocates that provide services and safety planning. And the safety planning is not just done as the victim enters, the advocacy program. It carries on through every step of the process. When a report is made, all the way through to when decisions are made about charging, the right to be able to, and this is outlined in the victim rights, to be able to meet with the prosecutor's office. And the frustrating part for me was always, when decisions are being made for example, by the prosecutors, they wouldn't always take the time to inform the victim directly of their decision, whether they're going to charge the case, or if there's some plea negotiations going on, or those decisions weren't always including the victim, which was really frustrating because, if the perpetrator is jailed and they're being released because there's no charges, then that victim needs to be informed sooner rather than later, because it is a safety issue for victims. If they were being threatened, that if they report, they need to know where that perpetrator is, if they're no longer being jailed. And then also supporting the victim through the process. And law enforcement meet the safety needs of victims. Oftentimes, it's helpful if, there's some kind of safety measures in place, even if, law enforcement can say, and I know that, law enforcement, they're not always fully staffed the way they want, and there's a lot of changeover and a lot of needs that still exist. But if, my warning, or kind of like word to law enforcement, is the issue of safety. Once a report is made, it's handed off then to the prosecutor's office after, the investigation occurs. And that process can be really volatile, really scary for victims. And they are involved in right from the beginning. And I always say the importance of that report that's being made, that's a huge step for victims. And it's important for law enforcement to understand that that's a huge step, and to take the time to take that report, and also to keep the victim involved as the case is investigated by whomever office that's happening. And then also, once the case is investigated, it's turned over to the prosecutors. They file documents to initiate the criminal adjudication on behalf of the tribe, and they represent the tribe during pretrial, trial, and sentencing. All the while, that victim should be kept informed of that process, and if nothing else, to involve the advocate to make sure that information doesn't fall through the cracks, because that can happen. Then we have the victim witness coordinators, who are working with victims as the case moves through, and trial is, there's trial preparation. Okay, next slide. Public Defender's Office, and they file documents to defend an individual who has been charged with the crime. They represent the defendant. Judges must remain neutral and impartial, maintain control within the courtroom to ensure rules of evidence and procedure are followed. We try to incorporate, the importance of looking at victim safety even within the courtroom, right? So that judges are aware that there's some things that can go on between the perpetrator and the victim or the perpetrator's family who are present in the courtroom, so that there's always that just that alert that victim safety is so important wherever this is happening, and that involves even in the courtroom. Corrections includes detention and community corrections such as probation, monitor the defendant after they have been sentenced or released from detention. So note that every criminal legal system will look different. The federal system will look different from the state and may look different from your own tribe system. Consider making a similar flow chart for your tribe's criminal legal process. And this is important for victims to take them through this journey, to take them through this. I used to call it the maze because it can look really scary to victims. And again, we want that victim-centered approach where we're keeping the victim involved in the case, so we're not losing them at a point where they say, I just can't do this because it doesn't feel safe, or it's just too scary, or I'm frustrated because I'm not being kept informed. And that's the whole purpose of victim rights, that they are involved and that they're kept informed and they're kept safe. Next slide. So the first step in that process is filing a report. And once when we talk about the criminal justice response and looking at victim rights, we always sort of tend to kind of glide over that report that's made initially. That's such a huge step. I can't say it enough, because if they're being threatened by the perpetrator, you report this crime, I'm going to kill you, I'm going to take the children, I'm going to turn you over to child protection, whatever the kind of threats are. That oftentimes making that report is a huge step for victims. They also will submit a witness statement, so they'll be interviewed by, the investigator, the CI, whoever is investigating. Will want a more detailed report, a more detailed statement from the victim in order to begin to build the case. They'll be required to testify perhaps at the pretrial hearing or at the bond hearing. And if there's also a criminal protection order hearing, they'll need to testify for that as well. They testify at trial, of course. They don't have the option to not testify. And usually it's the advocates that work in the prosecutor's office that will prepare them for that, taking them into the courtroom while it's empty to show them where everyone is seated and so forth. But the grassroots advocates can also, be present when that happens, or can also meet with the victim in a designated place. Again, the importance of safety is so important. Meeting with the prosecutor, this is so huge. This is important. I've worked in a lot of cases where the prosecutor often isn't available until like 10 minutes before the victim's going to testify. All that while, the prosecutor hasn't even had a lot of contact with the victim. And the prosecutor taking that time is so important. It just sends a message to the victim that that the prosecutor understands the importance of keeping that victim involved, keeping them informed, and then helping them prepare for the testimony, the kinds of things that will be done, that perhaps the kind of questions that may be asked, and just to sort of alleviate any fears the victim may have, and just keeping people on high alert that there's potential threats involved and so forth. So meeting with the prosecutor, in the victim impact statement, advocates can work with victims to prepare that impact statement, because that's, again, can be really emotionally draining for a lot of victims. But I've also worked with victims who are incredibly, incredibly eager to provide that, and also the victim's family, if that's appropriate. The victim may feel empowered to be able to have a voice in that process, in that step. I've even seen victims who've developed a video to say, this is how what you've done to me, how this has impacted me. So having the necessary resources available for victims to be able to make that kind of a statement is really important, whether it's the technology or whatever, to provide that platform for victims to provide the impact that this crime has had on them. Okay. Next slide. Is this Heather?
Yes. So as Bonnie has stated throughout the entire webinar, that thinking about victim safety throughout their entire experience with a criminal justice system is extremely important, and that includes protecting victim information. I've learned from Bonnie and Kelly and our folks here at TLPI that protecting victim information is the cornerstone of victim safety. So keeping their address, name, contact information, all of that protected is extremely important and can mean life or death for a victim at any point. And so you see all the different disciplines and professions that victims interact with when engaging, initiating the legal process and going through it. Lots of different folks are talking to each other and have to talk to each other to effectuate the process. However, there needs to be a paramount concern around how that information is shared across programs and across disciplines, and really want to promote victim safety and ensure access to all available services. So we just really want to prompt folks to really think about how your folks are sharing information, how you want to protect victim privacy, and protect victim information throughout that process of info sharing, and also how to make sure that you're facilitating collaboration so that the court processes are still efficient and reasonable to honor the victim's right to a speedy process. And we also wanted to prompt folks to think about a privilege within your tribal code, particularly a victim advocate victim privilege. And we talk more about that in the resource, and we actually provide an example. I'm not sure if this is Oglala Sioux's current code, but there is an example from Oglala Sioux where they codified a victim advocate privileges applicable in domestic violence cases. And it really just gets to the fact that you want to protect what the victim is sharing with their victim advocate, because their victim advocate is an essential support system through the process and through their healing journey. And so to really honor that relationship that's built and honor the role of the advocate and the needs of the victim, we encourage folks to think about a victim advocate victim privilege. And for those who may be unfamiliar, but I'm sure many of you know this already, privilege is an evidentiary rule that prevents disclosure of information, even if relevant in court, if there is a privileged relationship that's established by code. And so just to give it that highest protection and to really honor that relationship between the victim and victim advocate, we highly encourage tribes to think about a victim advocate privilege in their tribal code. And there's a few other places that we want folks to consider as well. Really thinking about exercising your powers as a sovereign nation when it comes to victims' rights. And those are on the next slide.
Yes, I love these examples. I love them and support them. And it's a huge statement in this current climate that we are in, to be able to look at fully exercising sovereignty as tribes to protect your citizens, right? So in addition to the core victim rights that exist in all of the laws, federal, state, tribes can consider going further, taking a step further with their protections and tailoring protections based on tribal values. And the right to, for example, the right to receive a referral to an advocacy program for support services at point of first contact. And I've said this before, at the doorway the victim enters, for every one of those agencies to say you have a right to, receive the support of our victim advocate or the victim advocacy program. And most tribes have them, and if not, to encourage putting those kind of resources in place, because like I said before, the laws are good, but the resources also need to exist, right? And that was the frustration at the very beginning when these laws came about, that there wasn't always the resources that were that were developed to, ensure that these rights are practiced. So I encourage tribes to make sure you have the resources, or where victims can access those resources that they have a right to. The right to have victim information shared with victim advocate is protected. That's really important. Like we've been saying, that they have that right to privacy and protecting their information that's being shared. The right to protection from intimidation and harassment or harm by the defendant, and anyone associated with the defendant. The right to receive a referral to a traditional healer and access to traditional healing resources. I just love that. To be able to even incorporate that right within your victim rights codes, I think would be just amazing. The right to receive information on the grievance process if codified rights are violated. Again, we go back to enforcement, right? The codes are only as strong as they're being enforced, and if they're not, then then something needs to happen, right? And if you have a team that's developing this, it's important for those team members to just monitor and be vigilant over when these codes aren't being enforced and what's happening. Why is it? Is it a communication issue? Is it a training issue? And to be able to resolve that, why they're not being enforced. Okay, next slide. I'll turn it over to Heather.
Thanks, Bonnie, and thanks everyone. I know some folks had to go at the hour mark, but we're wrapping up here. And so here on this slide, we just wanted to make sure that we provided you resources available to the federal statutes around victim rights, as well as searchable databases for victims' rights laws by state. As well as tribal laws. The National Crime Victim Law Institute also has links to tribal victim rights codes, as well as victimlaw.org. And victimlaw.org is actually pretty expansive. It includes not only codes, but constitutional amendments, court rules, administrative codes, and summaries of court decisions and attorney general opinions. So it's a pretty wide-reaching resource and database. So we wanted to make sure that we provided that all to you on this slide here. And then the next slide we have is just highlighting the resources, the resource that we have pulled from today. It's our Tribal Legal Code resource on victim rights. It's a condensed guide for drafting tribal victims' rights codes. You'll see in there the enforcement charts we discussed, the discussions of the core victim rights, the discussions of other provisions within victim rights that you might want to consider, such as your definition of victim. And also just general code drafting tips, and the teamwork approach that we discussed is also included in this guide. So we highly encourage you all to check it out and to share it with your networks. And I think what's next up is questions, if folks have any. And thank you all so much for your questions and chats throughout the presentation. Those were great.
Yes. Just a quick comment, in my work with teams that are developing codes, to be able to provide the team members that are actually at the table with these resources, I'm old school, so I like hard copies of everything. And, I always encourage teams to, put together like a packet of information for your your team members as you're developing these codes. So you have examples, you have resources, you have tools. So it's not like starting from ground zero.
Yes. Okay. I don't see any questions in the Q&A box or in the chat, but I do want to just also let everybody know that the QR code that's on the screen is also for the evaluation. I just want to thank everybody for attending today's webinar, which was titled Strengthening Tribal Victim Protections, a Guide to Drafting Victims' Rights Codes, and to thank again Heather and Bonnie for leading the presentation today. And again, as a reminder, the webinar recording will be posted on walkingoncommonground.org and will also be sent out to our mailing list and to those who attended. We do have links in the chat as well for the evaluation and the website as well. And we do want to note that this webinar is a part of a series of monthly webinars to support the development and enhancement of tribal courts, tribal justice systems, and intergovernmental collaborations. These webinars are brought to you by the Tribal Law and Policy Institute, the National American Indian Court Judges Association, and the Tribal Judicial Institute, UND School of Law. And our next webinar will be led by NIJA and will be on Wednesday, May 28th. And it is titled Strengthening Community Outreach and Engagement. And we should have a link as well in the chat box for that. So please register. And we will give you guys a few minutes to fill out your evaluation as well. Thank you very much.